If you are an immigrant in the UK, an international student, or a skilled worker hoping to settle down, you have likely seen the headlines and felt the panic. Over the last few months, UK immigration has become the single biggest political debate in Britain. Between the recent local elections, the meteoric rise of Reform UK, and the government's highly controversial new immigration white paper, the landscape of UK migration is changing faster than ever before. Today, we are cutting through the political noise and the fear-mongering to give you just the facts. Will indefinite leave to remain, or ILR, actually be abolished? Are we really looking at a £60,000 salary threshold? And what does the new earned settlement model mean for your future? We are breaking down both the radical political proposals and the actual, confirmed legal changes happening right now in 2026. Make sure you stay with me until the very end, because this might be the most important update for your UK journey. Let's get into it. Let us start with one of the most alarming talking points making the rounds, the proposed salary threshold hike. In recent press conferences and published policies, Reform UK has pushed for a staggering new minimum salary threshold of £60,000 annually for skilled workers. They argue this will drastically cut net migration and prioritize only highly specialized talent. But what does this mean in reality? Currently, the median salary in the UK is just over £31,000. For industries like hospitality, healthcare, transport, and even IT in regional areas, a £60,000 requirement would essentially freeze overseas hiring. But here is where our additional research comes in with a critical reality check. Even without Reform UK in power, the current government has already implemented massive hikes. As of 2025 and moving through 2026, the general salary threshold for the skilled worker visa has already surged from £26,200 up to £41,700. Furthermore, the minimum skill level was raised to RQF level 6, which is graduate level. Employers across the UK are already struggling to sponsor talent at this £41,700 mark. The idea of pushing it to £60,000 would transform the UK from a global talent hub into an incredibly restricted market, resembling the temporary worker models of Gulf countries. Now, let us address the elephant in the room. Indefinite leave to remain. During recent public addresses, figures from Reform UK suggested that up to 800,000 people approaching their ILR eligibility should have that pathway cut off. There was even talk of rescinding existing awards, which means stripping ILR from those who already have it. Legally speaking, retroactively cancelling existing ILR would require an act of parliament, trigger massive human rights challenges, and take years of complex litigation. However, while an outright abolishment might be a political fantasy, the actual system is currently undergoing a massive overhaul. According to our latest research on the government's 2026 immigration white paper, the UK is actively moving towards an earned settlement model. What does this mean for you? The traditional, flat 5-year route to settlement for skilled workers is ending. Under the proposed new rules, the default waiting period for ILR will double from 5 years to 10 years. Yes, you heard that correctly, a baseline of 10 years. From this 10-year starting point, your time can be reduced if you meet specific criteria. For example, if you can prove an advanced C1 level of English, you can reduce the wait by 1 year. If you earn over £50,270, you can knock off 5 years, bringing it back to the original timeline. But if you fall into lower skilled roles or have claimed public funds, your wait could be extended to 15 or even 20 years. This shift fundamentally changes the UK from a country where settlement is automatic after 5 years to one where permanent residency must be strictly earned through high financial contributions. On top of that, extending the wait to 10 years means thousands of pounds in extra visa renewal fees and immigration health surcharges for you and your family. Let's talk about international students. The political rhetoric currently claims that the UK student route is being used as a backdoor for immigration. Reform UK has heavily hinted at scrapping the 2-year post-study graduate visa entirely, aiming to stop students from settling permanently. In reality, the current government has already tightened the noose. As of earlier this year, the graduate visa duration has already been slashed to 18 months. Alongside cutting student benefits, Reform has proposed a new acute skills shortage visa. This would be strictly limited to critical sectors, possibly AI or specific IT roles, but with a major catch. For every overseas worker an employer hires, they must train one British worker. From an industry perspective, businesses in remote towns and smaller cities have already spent months trying to hire locally without success. Enforcing a strict one-for-one training mandate may prove completely unworkable for smaller employers who just need skilled hands on deck immediately. Another major proposal on the table is the UK leaving the European Convention on Human Rights and repealing the Human Rights Act. Why does this matter to migrants? Currently, Article 8 of the ECHR protects the right to a private and family life. If a migrant faces deportation or loses their visa status, but they have a British partner or child, they can often rely on Article 8 to keep their family together. Repealing these laws would remove this safety net, making it significantly easier for the government to enforce deportations and separate families without facing lengthy court appeals. To summarize, the UK immigration landscape is shifting rapidly. While radical political proposals like retroactively cancelling ILR or hiking salaries to £60,000 are not current laws, the actual confirmed changes are still incredibly strict. With the skilled worker threshold now sitting at £41,700, the graduate visa reduced to 18 months, and the proposed shift to a 10-year earned settlement model, the message is clear. The UK is making it harder, longer, and much more expensive to settle permanently. Please remember, the immigration environment is highly volatile right now, and everyone's case is unique based on their visa category and timeline. The details we discussed today are for informational purposes only and do not constitute legal advice. Because the rules are changing so rapidly, it is highly recommended that you consult with an expert, registered immigration lawyer to evaluate your specific situation and plan your future securely. Thank you so much for listening. If you found this breakdown helpful, please hit the like button, subscribe to the channel, and share this video with anyone who might be affected by these changes. Let me know in the comments below. What do you think about the proposed 10-year wait for ILR? Stay informed, stay prepared, and I will see you in the next update.